Everybody can hear me. Good afternoon, everybody. How everybody doing? Good afternoon, good afternoon, good afternoon. I'm gonna give y'all a few seconds to get in. Excuse me. All right, everybody. I'm gonna give y'all some time to get in, and then I'm gonna start. Excuse me. Sorry about that, y'all. Oh boy, this guy here, this attorney on here, man. This guy, he's something else, man. He is something else. Law Talk with Mike. Law Talk with Mike. Law Talk with Mike. When I do this video, the video is about 20 minutes long. I'll be, I'm gonna stop it from time to time and comment on it, provide y'all with some, commentary, stuff like that. Tell you where I think the guy in the case, if he's right or he's wrong. Kind of like how Yusuf L does his stuff. Which, if not, I would say exactly like Yusuf L does his stuff. And also, I want y'all to pay attention to the people over here. These are his subscribers. Excuse me, y'all. But just pay attention and read some of their comments of these sheeple, these subjects, these corporators, these dependents, these things, these people, these idiots, man. They are innocently idiots. Excuse me. And it kind of pisses me off. I'm not gonna lie. It kind of pisses me off, to be honest with you. On a scale of 1 to 10, how good can y'all hear me? On a scale of 1 to 10, how good can y'all hear me? Just post it in the chat. Once I know that the volume is good, then I'll go ahead and start it. I'll be right back, y'all. I got something in my throat. All right. Let me see. Loud, good. All right, good. Okay, so I'm gonna go ahead and just start the video. If y'all have any questions, y'all can just post your questions in the chat, and I get to them from time to time. So I'm gonna go ahead and I'm gonna start it. But y'all pay attention to some of these comments too.
Hello, this is Attorney Mike Griffin coming to you from Chicago. As usual, where the Wi-Fi usually works. I've got an old soft set. This happened about, the beginning of the year. It was one of the first clips where I saw Judge Oakley.
I'm gonna go ahead and just skip through this, and I'm gonna just get straight to the video. I think it starts somewhere, probably about right in here.
Be a nice trip down memory lane. Let's go.
Shaw Jr. Good afternoon, Your Honor. Muhammad on behalf of the people, P 86771. It's not me, that works. You're a senator. You don't please sit at the desk representing yourself. The judge needs to address you, sir. Is that a problem, sir?
Yeah. You're a defendant. Sit at the defendant's chair.
I'm not defendant.
Now I'm live. Can y'all hear the background? Like, can y'all hear this video right here? If not, I'm gonna have to see if I can change the volume. I mean, change the microphone or something like that. Could y'all hear everything? Just let me know if you can, and I'll go back to the video. sometimes when when you go live like that, you can't hear the video. Volume is too loud, so it's distorted. Yeah, loud and clear. Okay, some of them loud and clear. Okay. I guess I'll try to turn my volume down on my computer a little, and hopefully that'll help. Let's get back to the video.
I'm sorry, Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen. No, I'm not a sovereign citizen.
All right, sir, don't speak.
I may be not phrasing that.
Don't speak until I ask you to speak.
But there is a difference.
All right, look, I'm gonna stop right there. First off, he can't tell you when to speak and when not to speak. He doesn't have that authority. Now they do abuse their authority like that, but generally speaking, he can't tell you when you can and cannot speak. Okay, he is a public servant. You have a you have a right to speak. Generally speaking, you have a right to say almost whatever you want. Almost. You can't. There's certain stuff you can't say, like to the extent that something is not true. That would be slander. So no, you can't. You can't say something that's not true. You can't write something that's not true. But you don't. Like, he doesn't give you permission to talk. He is a public servant. This right here, even though they call him so-called judge. This is not a judge. This is an executive administrator. And in this video, he's going to tell. He's not going to expressly say it. He's going to implicitly tell you everything that I've been telling y'all on my channel about these so-called administrative law judges, if that makes sense. These executive administrators. I can't even believe he said it. I cannot believe he said some of the things that he said in this video. Look at this idiot right here.
To show, or I think it shows assertion that there is a difference between.
One more thing. When they tell you don't speak this, like, generally speaking, they're violating your right to due process, because they're saying that you can't speak unless I give you permission to speak. But we haven't had a trial on this. They're violating your right to due process. Like, freedom of speech is a fundamental right. It's a private fundamental right. It really exists independent of the federal Constitution. This is a God-given right. And he's telling you that you cannot speak. He's depriving you of that right. Now, what you can do, I don't know, like in some places, this is what they do. Normally, when somebody is saying something that's not true, obviously you're supposed to object. In some places, that's what you do. I'm not sure if this is a so-called court where they do that at, but and in some places, you just you kind of just be quiet, let the other party speak, and then after the other party finished speaking, then the so-called judge will look at you and ask you if you have any objections. That's what they're supposed to do. Unless now, if you're a pro se litigant, they're probably not going to do that. They're just going to automatically just ignore you, act like you ain't in the courtroom, and just go with the flow. That's what they're going to do. But you have to object. Always object to something that's not true. It lacks foundation. It's irrelevant because it lacks foundation. It's hearsay. It's inadmissible. It doesn't qualify for an exception under the hearsay rule. Stuff like that.
Actual person, Mr. Franco, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we'll proceed.
All right, so you're threatening me?
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
And if I may, I have advised Mr. Michaud that the courts receive objections all the time, the rule objections that are preserved on the record. If he has,
So you can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
are you going over?
Yes.
Are you going to go to the Constitution?
Hold on, are you picking them up? That's one of the reasons I want you up here, is there's a microphone here.
Oh, I'll speak on.
Are you picking them up? Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution?
I didn't swear an oath to the Constitution.
You have.
I took an oath that said I would follow the Constitution.
to not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay? Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to.
Look, man, they can't talk to you like that, man. They can't talk to you like that. What this man here, based off this one video, I don't know how he is anywhere else, in other videos. This is the only video that I have that I recall seeing of this so-called judge. Looks like his name is Brian. Looks like that says Brian A. Oakley or something like that. I think that's this so-called judge's name. They can't talk to you like that, man. They can't talk to you like you are beneath them and they are above you. No. I would have reported him. Nothing probably would have happened, but I still would have reported his ass. Another thing, the issue is they're trying to get this guy in this so-called administrative hearing, because that's what it is. It's not a court; it's an administrative agency. But they're trying to get this guy, to say that he's the legal name and he's this legal entity subject to their corporate territorial jurisdiction without saying it. But that's what they're trying to do. So, but they don't really want to respect anything that he's saying. That's why the so-called judge said, I don't recognize that. So what you should do, this is what I do. I don't give a damn if he recognizes it or not. What I do is I make a record. I let my paperwork talk for me. And then if they want to test me, because they will test you and start asking you questions. What did this word mean? What does this word mean? Stuff like that. Me, I pass the test. I answer the questions. And they shut the hell up and they stop asking me questions. That's what they do. Or if I don't want to answer any questions, if you don't want to answer any questions, you say, with all due respect, Your Honor, I'm not here to answer any discovery questions. I'm not here to answer any discovery questions. I'm here on a special appearance. All right. You have my notice of special appearance and demand for the nature and cause of each. I'm not the cause, but you have my notice. I forgot what I called it. What did I call it? Demand for this is the notice of special appearance and demand for the nature of this. What is it? I forgot what I called it, but it's a document that I drafted probably about a month ago. That I just got bored one day and I drafted it. But anyway, it has everything in there that I could think of, at least right now, regarding territorial jurisdiction, in personam jurisdiction, the nature of the accusation, the prerequisite, all of the prerequisite factual elements of the affair. It has everything in there for double jeopardy, like everything in there. I just got bored one day and it took me a couple of hours and I just did it. But that's what I would file. I would file something like that. And that would be it. To be honest with you, I wouldn't even answer any questions. I would just file it. I'm not here to answer any discovery questions respectfully. And I'll go over here and sit down over here on this chair, but don't how do I word this? Don't take me walking over here, sitting down in this chair as me subjecting myself to this jurisdiction or anything like that. I'm only doing this under duress because if I don't do it, you're going to probably hold me in contempt of court, which is unlawful because they don't have unbridled, unrestricted authority to hold you in contempt of court just because they want to. No, they don't. They will do it, but they don't have that authority. I'm telling you what I know. Let me show you what unbridled. Let me show you what unbridled means. Let's go to Google. It's really like carte blanche, if that makes sense. So I'm gonna say carte blanche right here. They don't have carte blanche authority to hold you in contempt when they want to hold you in contempt because you don't want to do something that they say. Complete freedom to act as one wishes or thinks best. No, they don't have that authority. All right, let's get back to the video. Right here.
Have an exam today, get your ass in the chair. That's the way it works. I would have nothing less. Now, are you representing yourself today?
I'm representing myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
All right, so that's a no, you don't want him to represent you?
No, he's, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommend.
Look. For me personally, I don't ever, now that I know what I'm doing, I used to do it in the past, but now that I know what I'm doing, I don't ever decline counsel. I don't. What I do is I let counsel handle, counsel will take first chair and I'll take second chair. And then I'll know what counsel is supposed to file and what he's not supposed to file. And I'll know if I'm supposed to take this deal or if I don't supposed to take this deal. Me personally, because what you have access to to that entire record once you are party to the case. You can go down to the courthouse and request a copy of everything that is in your case file, and everything that has been filed in the docket under your case number. They have to give you that, or they can't use it against you. They have to give it to you. So with me knowing what I know now, I would just, to be honest with you, I would probably draft maybe about like 99% of my paperwork if I had a public defender. Hey, look, I'm going to draft this. I will give him the paperwork. This is what I want you to argue. If he don't want to argue that, then I will fire him for ineffective assistance of counsel. Something like that, because I want it to be because he doesn't want to make arguments that I think he should make. Something like that. I don't want it to be the reason why I do that is for ineffective assistance of counsel claims and stuff like that. Also, it's because if I'm not mistaken, let me go on case text and try to show y'all why. I want to say I think it's a jurisdictional prerequisite. If I'm not mistaken, they have to appoint you counsel, because if they don't, they violate due process. So let me see. I think it's appointment of counsel, jurisdictional prerequisite, probably spelled it wrong, and due process. So let me see. I'll come back to the chat in just a second, y'all. Give me like 5 minutes or less, and I'll be back in the chat. All right. Okay, let's see. The authority to appoint counsel in such proceedings derives from due process. Okay, so this is why they always want you to knowingly, intelligently, and voluntarily waive your right to counsel. They'll give you what they call a Ferretta hearing, or Ferretta colloquy, or something like that, to where you can to where they want you to knowingly, knowingly, intelligently, and voluntarily, if I'm not mistaken, waive your right to counsel so that they can start exercising jurisdiction over you. Let's see. When personal freedom is at stake, the United States Supreme Court has held that a due process basis for appointment of counsel is established. Let me see. I don't want to talk about no statutory rights. Let's go. I'm going to say criminal cases. This is just a overall general understanding of this stuff, y'all. Right here, an indigent person has the right to appointment of counsel by statute and pursuant to the constitutional guarantees of due process. So it's a due process issue if they don't appoint you counsel. I don't never waive mine. Not now, knowing what I know now. I don't ever waive it. I let counsel get pissed off because I don't want to listen to him. And he'll probably file a motion to withdraw, and I would object on him filing a motion to withdraw to the extent that if he thinks I'm being difficult, if he's lying on me in any type of way or something like that, especially if he calling me a sovereign citizen or something like that, I would object to all that stuff. What you're trying to do, you have to make a record of this stuff, man. Where we at? Right back here.
To Mr. Michaud is that he has a jurisdictional argument that he wants to make, and that pending Your Honor's ruling on a jurisdictional issue, I have prepared for, to conduct a preliminary exam.
Okay.
And could be, available if he wanted to ask me to do that at the correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for
Okay.
So, with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
Look at this. You see this right here? Spoiler alert. He has jurisdiction. No, the hell he don't. You can't just say I have jurisdiction. It doesn't work like that because this is not a court. Okay, this is an administrative agency masquerading as a court. And once you challenge their jurisdiction, they have to prove it on the record, in the affirmative, every element. Again, let me show y'all what I'm talking about. They call them courts. They're not courts, all right? Probably spelled proceedings wrong. Yeah, I did. Boy. This is a principle. I don't care if it's in Michigan or not. This is a principle everywhere that is established all over this country. However, as courts of inferior, he's going to, man, look, this man here so bold. He going to tell you exactly what's going on without telling you exactly what's going on. However, as to courts of inferior or limited jurisdiction, jurisdictional facts must affirmatively appear on the face of the record. This is a principle. I don't care if this is in West Virginia. All right, but we're going to go to Michigan because he's in Michigan. All right, we're going to go to Michigan because I want y'all to see this. Let's see. Where are we at? Let's go. This might work right here. This is from 2022. It is a well-settled doctrine that when proceeding to exercise the powers conferred, inferior courts of special and limited jurisdiction must have jurisdiction of the person by means of proper process or appearance. So you can voluntarily make an appearance down there, as well as subject matter of the suit. And when they thus have jurisdiction of the person and the case, if in further proceeding they commit error, their proceedings are not void, but only voidable and may be reversed by error, blah, blah, blah. Trying to get it to find it one that's directly on point. So let's see. Court of limited jurisdiction must appear on the face of the proceedings. See if I can find it. The record of a court of general jurisdiction. Okay. That's for courts of this right here is for courts of general jurisdiction. The other one is for courts of limited jurisdiction. I'm trying to see if I can find it. Matter of fact, I might be able to do it like this. Y'all give me a second. I think this will work. Now, excuse me. We're in Michigan. That one should work. All right, here it is right here. A court of special, limited, or inferior jurisdiction must, by its record, show all essential or vital jurisdictional facts of its authority to act in the particular case. and in what respect it has jurisdiction. Because the reason for that is because they are not entitled to the presumption that they have jurisdiction, because their jurisdiction is extremely limited. Here's another one. So the necessary jurisdictional facts must affirmatively appear by averment and proof to bring the case within the jurisdiction of such courts. This is a principle. This rule also applies to jurisdiction over special statutory proceedings exercised in derogation of or not according to the course of the common law. He's going to tell you all of that in this. I can't believe this man said this, y'all. This is what he's going to tell you. I'm sorry I keep stopping it, but there are some people who are on Mike's channel. They're probably going to come and look at this video, and I want them to see this. So that's why I have to show them these cases. All right.
I understand, Judge. I'm definitely going to stay.
That's fine.
So, today,
You have a jurisdictional argument you want to make?
what I served notice
Sir,
on,
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes or no?
Why are you forcing me to say, answer?
Look, man, they can't tell you the answer. They can't force you to answer their questions by talking over you and ignoring you. When they do that, they're trying to cut you off. There's a court report in there. What they normally do, they'll do that to stop you from trying to make a record, to confuse you. That's what they'll do. They do that to me a lot.
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional argument?
I'm presenting myself, so I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is this?
I really like up under.
So, what this man is trying to ascertain, what he's trying to find out is, which jurisdiction is this administrative agency prosecuting this case under? Is it common law? Is it equity? Is it admiralty, or is it maritime? That's what he's trying to find out. He's going to say state of Michigan. That's not answering the question. But it gets more interesting. Y'all just pay attention.
What jurisdiction does this court operate up under?
District courts are legislative courts. I mean, just created by statute.
Did y'all hear that? Did y'all hear that? Did y'all just hear that? He just told you that this is an administrative agency, aka a so-called court of extremely limited jurisdiction. This is a legislative so-called court, which means he is not a fucking judge, which also means he has zero judicial authority, because the legislature does not have any judicial authority to give him, because they have so-called separation of powers. But we crazy, right? We crazy. We don't know what we talking about. Let me go and check the chat right quick. Let's see. All right, loud and clear. If everyone just reads the documents of Congress service, it'll tell you what's they are an agency of Congress. I need to ask the judge in court. That is attorney and client violation. I'm not really sure what that means. I may have to file bar grievance on your attorney to let him know you're serious about the contract. I'm not really sure what that means either. But anyway, now y'all gonna hear me say some stuff that y'all have already heard me say. All right, but I have to say this because, again, some people on from Mike's channel, they're gonna come over here and they're probably gonna watch this video and they're gonna give it a thumbs down and they're gonna talk about me and they're gonna make fun of me and call me names, yada yada yada. I don't care about none of that. But so for everybody who's coming from Mike's channel watching this video, all right, I'm not sure when they did it for your particular state, but a long time ago, all of these so-called courts were separate courts, okay? And because they were separate courts, they had their own rules of procedure that govern how you prosecute cases in each of these so-called courts. That's what they did back then. However, move forward, fast forward. Now, They have merged all of those buildings, all of that authority into one individual man or woman. Okay. That's what they did. And what they did with the rules, they did the rules the same exact way. So let me show y'all what I'm talking about. I'm going to take it off here because I want to broaden my search. I'm going to take it off Michigan, go back up here, and I'm going to say, we're going to say let's do the criminal rules of procedure. We're going to say equity, law, admiralty, and maritime rules were consolidated in the criminal rules of procedure. We're going to say something like that. Now, they might say civil procedure or something like that. All right, so where is this? This is Fifth Circuit, 1981. So it says in 1966, civil and admiralty rules of procedure were unified for federal court. So they consolidated them. All right, here's one right here, 2002. At that time was this the rules of practice in admiralty and maritime cases, which took effect in 1920, were rescinded as of 1966. At that time, admiralty rules were merged into the civil rules of procedure. So they don't call it admiralty rules of procedure or nothing like that. They don't call it equity rules. They don't call it law rules. They don't call it maritime rules anymore. They call it the federal rules of civil procedure and the federal rules of criminal procedure. And they did that everywhere. So if you're in Georgia, all right, Georgia has some sort of code. I don't think they have a rule of criminal procedure. I could be wrong, but if you're in Georgia, what they did was they codified all of these rules into a code. If you're in probably Utah has rules of procedure. If you're in Utah, they they adopted into a rule, a set of uniform rules throughout the state of Utah, the admiralty rules, equity rules, common law rules, and maritime rules, and they merged them into one set of rules. They consolidated them, and they call them the Utah Rules of Criminal Procedure and the Utah Rules of Civil Procedure. That's what they call it now. Originally, separate rules of procedure applied to admiralty case. Are y'all paying attention to this? Originally, separate rules of civil procedure applied to admiralty cases. In 1966, the federal rules of civil procedure were amended to provide uniform rules for admiralty and non-admiralty cases. Give me a second, y'all. I'll be right back. They always start calling me when I go live. It just never fails. They just blow my phone up. Let me see if I can find some more. Here's another one right here, 2011. The 1938 adoption of the rules, specifically rules 1 and 2, united actions of law, and it didn't just do common law and equity. United actions of law means common law, and equity means chancery, courts of equity, yada, yada, yada. So that they may be tried together. In 1966, admiralty procedures were merged with actions of law and equity. Thus, the federal rules permit joinder of legal, equitable, and maritime claims. And this is what they did. They merged every damn thing together. They put all the buildings in one building and merged all the shit together. That's what they did. All right. The reason why you want to know the nature of the action, because you need to know how to plead your defense, because certain affirmative defenses are only applicable in admiralty. Certain affirmative defenses are only applicable in, equity is applicable all around. But it's best to know the jurisdiction that the case is being tried under, because there may be some due process defenses that you need to raise, but you don't know how to raise because you don't know what the nature of the action is, and that's why we're trying to find out. I'm saying we're trying to find out what's going on. Also, another thing they did when the courts were separated, to invoke the jurisdiction in the common law court, you had to file what they call a declaration. Okay, they don't call it a declaration no more because they merged everything together. They called it a complaint now. In admiralty, you had to file what they call a libel. All right. Today, they don't call it a libel anymore because they merged everything together. They call it a fucking complaint. In equity, they call it a bill in equity. They don't call it a bill in equity anymore because they merged everything together. They call it a complaint. They call every damn thing a complaint. This is what's so confusing. All right. That's what they did. This is what he's trying to find out. All right. This man ain't crazy. He probably don't know what he's doing all the way through, but he ain't crazy. We're going to check the chat. Well, that's true to a certain degree, SG, but you don't listen. There are like 4 ways that you can bring a motion. You can use a rule of procedure, you can use the Constitution, you can use a case law, or you can use a statute. Me personally, I probably wouldn't use a statute. I would use either a rule of procedure, a case law, or the Constitution. That's what I would use. Now SG. Now you're right, but some of them are courts of record, like a juvenile court, child support court, something like that. They are courts of record, and this is what I've been trying to tell people. What these inferior so-called courts are doing is they're trying to make their inferior courts, these legislative courts, these administrative so-called courts, look and function just like common law courts. That's what they're trying to do. That's actually what they're doing. They're not trying to do it. That's what they're doing.
The state of Michigan.
This one more time. This is what he said.
What jurisdiction does this court operate up under?
District courts are legislative courts, and you just created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that?
I work under the authority of the state of Michigan.
What is it? What jurisdiction then?
Another word. He is in a. This is what this guy probably doesn't understand is he is in a territory. That's why when he says statute, all legislation is territorial. He is in a territory. I'm not sure what so-called city or what county this is in, but he is in a territory. All right. So when you're in a territory, generally speaking, you're dealing with a territorial government. You're not really dealing with the state. You're not dealing with the state government. You're dealing with some sort of administrative agency because a county is an administrative agency. A city is an administrative agency. To the extent that they're incorporated, they're all administrative agencies. And since they're all administrative agencies, they're all members of the executive branch of government because that's what administrative agencies are. They're executive officers. That's why we call them executive administrators. This is not a fucking judge. He is an executive administrator. He is following statutory procedures and he's enforcing statutes. And members of the judiciary do not do that. They don't do that. And they can act. Members of the judiciary can act without statutes or with statutes. Their jurisdiction is extremely broad. His jurisdiction, aka authority, is extremely limited as to what he can do.
There's 2 different districts under the Constitution. You have admiralty and common law. So I need to know.
This is not admiralty. And it's not common law. It's statutory.
Okay, so it's statutory.
Did y'all hear that? It ain't common law. It ain't admiralty. It's statutory. He just admitted that they violated due process. He blatantly just violated this man due process rights because there are no civil rules for statutory procedure nowhere that I've ever heard of. There are no criminal rules for statutory procedure that I've heard no fucking where. He just said it ain't common law. It ain't admiralty. What is it then? It ain't equity because equity doesn't have a criminal jurisdiction. There's only 2 out of these 4 jurisdictions, which is common law, equity, maritime, and admiralty, that have criminal aspects to it, and that's common law, and that's admiralty. That's it. We know it's not common law because there's a statute involved. There are no statutes in common law, so we know that. I just wonder what it is. I wonder. I already know what it is, but anyway.
Statutory, that is what, civil?
No,
So what is it?
my jurisdiction is both
I
civil.
can't defend myself unless I have it on record. Is it?
My jurisdiction.
It's only 2.
Sure, shut up. If you ask me a question, I can't answer when you're talking.
Okay.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under what?
He's in a territory. He's an executive administrator. He's always talking about statutes.
Which one is?
This is a criminal case.
Okay, right, so.
This is a criminal case. Let me show y'all what I'm talking about. Equity does not have a criminal jurisdiction. Okay, these are the principles right here. This is Nebraska. This is Ohio. It is well settled that equity, as a general rule, has no criminal jurisdiction. A court of equity is in no sense a court of criminal jurisdiction. A chancery court has no criminal jurisdiction and will not exercise its power solely to enforce criminal laws. Equity has no criminal jurisdiction. This is a principle. That's why you see it all over the damn country. A court of equity has no jurisdiction in criminal matters or immoral. It is, of course, true that equity exercises no criminal jurisdiction, so it's not equity. And we heard the so-called judge say it's not common law. Okay, I know it's not common law because there's no man or woman in there with a sworn complaint, with a claim against him, saying that he stole from them, saying that he injured them, he violated their property, he assaulted them, he battered them, or something like that. The state of Michigan, which is a corporation, is the plaintiff. What's confusing people is the state of Michigan. It does not confuse me. The state of Michigan is a fucking corporation. It has an EIN number and it has a DUNS number. It has insurance as well. It is a legal person. It is a person. It all makes sense to me. None of this stuff confuses me no more.
Is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
Then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right, where's the former statement?
Where's what?
No, it's not the people for the state. No, it's not. No, it's not. No. I am one of the people. And my name ain't on that piece of paper. You don't represent me. I am one of the people. Let me show y'all what I'm talking about, man. Where is that? There's a document on here. It's in my email. Let me go and pull it up right quick. Well, I'll go and pull it up right quick. I'll pull it up right quick. I wasn't going to do it, but I'm going to do it today. So it is sent. I don't know who these people are. Right here. This is a document that I did a while ago that I mentioned earlier. Okay, I am one of the people. Okay, I'm one of the people. This is a principle that I'm about to read y'all that applies everywhere. Okay, it applies everywhere. But the people themselves are not creatures or creations of the legislature. He just told y'all you're in a legislative court. Did he not just say that? They are the father of the legislature, its creator. And in the act creating the legislature, the people, the sovereign, we're talking about right here. This is a case from Utah. All right, but I'm gonna reference I'm gonna reference it into the for the people of Michigan. That's what I'm gonna do. Its creator, and in the act creating the legislature, the sovereign people of Michigan inherit all political power and being co-equal in legislative power. The legislature, the child of the people, cannot limit or control its parent, its creator, the source of all power. This is a fucking principle. I don't care if this is in Utah. This is a principle, and this principle is recognized all over the damn country. Now, let me show y'all something else, people who follow Law Talk with Mike. Let me go back to my YouTube channel and show y'all something. Because y'all think we just be making shit up. I don't make shit up. What I do is I find cases, I read the cases, I come back and I report the cases to my listeners and my viewers and my followers. That's what I do. Let me show y'all something. Everything that I cite on here, it says it in the case. It either says it expressly or implicitly. Now I'm about to cite y'all another case that is going to say exactly what I just read, y'all, but it's going to say it in another way. It's going to implicitly say it in another way. So expressly say it in another way. I got to find it. Y'all give me a second. It's out of, I think it's out of Iowa. I found it in a case. I read this case and I noticed that the so-called judge who wrote the opinion, she omitted it from the case. Let's see. Where is it at? This is one of them right here. Well, this is, I don't really want to read all this, but in this case right here, y'all can go and read this for yourself if y'all want to. All of the followers of Mike, this is the case citation right here. It's from 1971. In this case right here, the so-called state of Louisiana, which is a corporation. In this case, the state of Louisiana was arguing that it was a person, a corporation, and that it was trying to sue for libel and I think it was either for libel or slander, because somebody had posted something and it hurted the state of Louisiana's feelings, and they tried to say that they were a person and a corporation and that they had a right to sue. And now the court recognized, so-called court anyway, said that, yeah, you're a person, but you're not a person to the extent that you have this right to do this. That's essentially what they said. But let me go to the case that I wanted to show y'all. There's the case. Again, if you think I'm lying, go read the damn case. It's right there. There's the case citation right there. Go read the damn case. All right. Where is it at? I'm almost got it. Y'all give me a second. I got to find that to show them this. Cause they think we just be making shit up, y'all. They think we crazy. They just call us crazy. Come on. I think this is it right here. Yeah, this is it right here. This is out of Iowa. It's out of Iowa. The best cases are to read are the old cases. But y'all think we just be making shit up. Okay, we think we just make up shit. Okay. Anyway, again, this is out of Iowa. Iowa Supreme Court. This is the case citation. I don't give a damn if this is out of Iowa. This is a principle. It applies everywhere. Anyway, The people are sovereign and speak through their constitution. And when they thus speak, they being the people, its mandates are binding upon all people and on the legislature, which is but one of the agencies of government, aka one of the agencies of the people. The government is a fictitious entity. The government is a fictitious entity. The government is a fictitious entity created by the people, a corporate entity. It's a damn corporation. It's a body politic and a body corporate. That's what the fuck it is. That's why they have EIN numbers and DUNS numbers, and that's why they have insurance. That's why they file lawsuits against your ass for speeding, allegedly speeding, or you running a red light, or you riding down the street, or you walking down the damn sidewalk with a damn beer in your hand. They filed a lawsuit against you. You don't know that they're suing you, but that is exactly what they're doing. They have filed a lawsuit against you. They're suing you. The government is a fictitious entity created by the people, a corporate entity through which the people act. All departments of government and officers are only the instrumentalities through which the government acts. All of these departments, they're all administrative agencies. Every damn last one of them. They're all administrative agencies. All right. Let's get back to this. I just get so tired of this damn dude and these people who don't read. They don't know what the hell they talking about. It's just always just making fun of people, calling people names and shit. And they don't know what the hell they talking about. Mike is lying to y'all. If you are a follower of Mike, okay, when it comes to this stuff like this, he's lying to you. Now, as far as what he actually practices in these so-called courts, he may be good at that. I don't know. But this, he needs to stay away from this because he's lying to you. He is knowingly and intentionally misrepresenting patently false information to his subscribers. That's what he's doing. But you ain't getting me, though. Don't work on me. Don't work on me, my dog. All right, let's get back to the video.
A sworn statement, I have a right to see a sworn statement saying I entered sworn.
There's a complaint in the file.
Sworn complaint, signed,
You want to see it?
affidavit, sworn affidavit.
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party. You have my injury for the record.
The state of Michigan.
How can I
Bring the charges.
How can I
Sir, sit down. Sit
I'm
down.
not.
Sit down, or I will hold you in contempt.
Another grade. Wow.
They can't just say they're going to hold you in contempt for no reason, man. You're not sovereign. You're a public servant. You're an executive administrator.
You're probably going to hear more than one.
I see.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, would request a mutual order of sequestration with an exception for the YC.
So again, I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the name. Would you mind putting your name on the record?
She's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name?
No,
That's fine.
I agree that he doesn't know what he's supposed to say. I think even the way he said it, helps his argument.
Thank you.
Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611B, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on, have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here on the probable cause conference, and I don't know how we here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary hearing.
This is, okay, so right here.
This is the probable cause hearing.
It says.
Stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal objection is.
I'm also objecting.
What is your legal objection?
To not waive my probable cause hearing.
Denied. That's admitted.
This guy, he honestly, he don't really know what he's doing. Okay, when you make an objection, your objection has to be, well, it really depends on where you are. But in my opinion, the best way to make a objection is to be a specific objection. You can't just make a general objection. You can't just, a general objection is like objection hearsay. No, you can't do that. That's a general objection. I don't like those objections. When you state your objection, you need to be very specific. Objection, the evidence, objection, lack of foundation. Your Honor, this man is not a witness. And also the document that he is trying to admit into evidence, there's no witness to come in and to lay a foundation to this document. Something along those lines. Something like that. That's what you call a specific objection. I can't really freestyle this stuff off the top of my head, but once I take my time and read over this stuff like that, then that's when I make my objections. I'm pretty good at written objections. I'm still working on making oral objections on the fly like that. I'm still working on that. But written objections, I'm pretty good at those. Another thing is this guy, sometimes the judge, so-called judge anyway, he seems like he's trying to tell this man a little as to what's going on, because the guy doesn't understand that this is if I'm not mistaken, I think this is a preliminary hearing, aka a probable cause hearing or something like that. And I don't think the guy understands. I don't think he understands it. So either there's some mistakes in his paperwork that is allowing him, or that is causing him, if that makes sense. I think that's a better way to say it. That is causing him to misinterpret what's going on, or he just simply doesn't know what the hell going on. I don't know the guy, but he doesn't seem like he knows what's going on all the way. Some of the stuff, he kind of does, but then he really doesn't.
Which is number one, wrong.
Under what grounds am I denying?
Because you didn't give me a valid objection.
I object.
You can't just object. You got to explain what the valid objection is.
That we are having a preliminary exam when I haven't had a probable cause hearing, and I did not.
They're the same thing.
It's still on this.
Mr. Michaud, they're the same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different day that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two?
Have you ever had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, at the probable cause conference first on November 29th and then again on December 20th. I have disclosed, I think I've been very transparent aware, Mr. Michaud, that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
I'm gonna go to Google and see what they mean when they say probable cause conference or probable cause hearing or something. Because this is different. Okay, this is in Michigan. I don't really know what the hell they do in Michigan, but it seems like it's kind of similar to what they do everywhere else. They might just call it something else. There it is right there. Probable cause conference. A probable cause conference is a court hearing that takes place in Michigan before a felony case's preliminary examination. It's the first opportunity for a defense attorney to negotiate with the prosecutor. The PCC is usually mandatory unless both parties agree to waive it. So let's see. Here are some things that can happen at a PCC. Plea agreements. Prosecutor and defense attorney discuss possible plea agreements. Bond. The judge may consider requests to modify the defendant's bond. Preliminary examination. The PCC can schedule a date for the preliminary examination. Case resolution. The case may be resolved in district court by reducing the felony charge to a misdemeanor. Alternative programs. The defendant may be able to bargain for alternative programs that could result in dismissal. Prosecutor's case. The defendant can get a closer look at the prosecutor's case. The PCC is usually scheduled between 7 to 14 days after the defendant's arraignment. Okay. The defendant can have a criminal defense attorney present to help them understand the legal process and question. See, I don't think they do this everywhere. I've never heard of this before. A probable cause conference. I've never heard of it. You know, they may do it, you know, in some states, but I don't think every so-called state does this. Because this is my first time even hearing about this. That's what they're doing in Michigan. This guy, he doesn't seem to understand this, you know. But it's anytime you don't know what's going on, like you got to go online, you got to do your research, or call around and ask somebody for some help. It's best to just, if you can't get in touch with anybody to help you, it's best to just get online and do your research, read cases, something like that, because you can find this stuff online. See, I just found it, so you can find it online. Let me get back to the chat, see what's going on. Treason, my Lord, please forgive these evil actors. Inferior courts and court of, okay, no money of exchange, so it can't be admiralty, hence colorable admiralty, since it involves colorable money. I agree with that. SG. He's referring to lowercase people, not people. I agree with that as well. Notice the case difference in people in the the case difference in people in the U.S. Constitution and people in the state of. I agree with that. The people of the territories are not the people of the United States. I can agree with that as well. I can agree with that. It's unfortunate that you have to be this, I guess, intelligent to understand what these people are talking. Like they just speak in. It's like they speak in another. Well, they are speaking another language. I was going to say it's like they're speaking another language, but they are speaking another language called legalese, and they're also using the rules of English grammar to communicate, and that's what you need to learn as well. The people created the state of, therefore, the people would be the legislature, wouldn't it? I would say that. Yeah, I would say that because the legislature they represent the so-called people, if that makes sense. It's like they are, to be honest with y'all, they are all it's like they're all our attorneys or something like that. I forgot. I don't know how to word it, but it's like they are your attorney. You know, you hired them. They're your agent to represent you. There's some cases on it actually. I have them on my computer, but I don't feel like looking for them right now. Common law is the law of the land of the people without statutes. I eject, is this civil or criminal contempt? Eject? I don't think that's the correct term. The judge has not authority to have someone held in contempt. Civil or criminal contempt requires a notice to appear and show cause. Well, it depends on what kind of contempt it is, SG. So let me show you what I'm talking about. Is it direct contempt or constructive contempt? Direct contempt is something that the so-called judge sees and he can go ahead and summarily punish you right then and there. And was it direct or constructive? Yeah, let me hold on. Contempt versus we'll do it like that right here. Okay, the main difference between direct and indirect contempt is whether the act occurs in the presence of the court. Direct contempt occurs in the court's presence or within hearing distance and can be punished without a trial. See that, SG? Examples include disobeying a judge's order, creating a disturbance in the courtroom, swearing at the judge during a trial, blah, blah, blah. Occurs outside the court's presence and requires the court to rely on third parties to prove the offense. Also known as constructive contempt, like I said a little earlier. Examples include failing to comply with probationary orders outside of court, attempting to influence a juror during recess, advising a client to violate a court order, failing to pay spousal support, yada, yada, yada. So that's the distinction between constructive and direct contempt.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to explain.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you got to be quiet when we're talking. Clear?
I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony.
Okay, see, I told you I ain't never heard of this. That's just something that they do in Michigan, probably. But so what he is today is at a preliminary hearing. That's where he is today. This is a preliminary hearing where the state has to essentially prove that there is probable cause to move forward with a trial. The standard of proof for the state for a preliminary hearing is less. So let me see. See if I can show you. Let's go to case text. So burden of proof at preliminary hearing is less than trial, if that makes sense. So this is like a federal court. Let's go to Michigan. Well, it really doesn't matter because it should be the same all over, to be honest with you. So it really doesn't matter. But this is a principle, all right? So this is a federal court in California. This is a California state court. The burden of proof at a preliminary hearing is less than that required at trial, requiring only reasonable or probable cause. The state's burden of proof at a preliminary hearing is much less than at trial, and the state need only show that a crime was committed and probable cause to believe that the defendant committed the crime. All right. Let me go to Michigan. Michigan should be the same thing because, like I said, this is a It's a principle, so it should be applying all over the country. All right, so this is 2017. Thus, the prosecution's burden of proof at the preliminary examination was lower than its burden at trial, where it was obligated to prove every element of the charged offense beyond a reasonable doubt. And that's the trial standard. You have to prove every element of the offense. Admittedly, the standard of proof at a preliminary hearing is lower than the standard of proof at trial. So he's at a preliminary hearing. So a preliminary hearing, it seems to be like an indictment hearing or something like that. It's like it's just easy. I don't know. I could be wrong. I'm just speculating. But anyway, back to it. I just wanted to show y'all that, just in case if y'all have any questions about it.
Do you have any questions based on that?
And we'll point it out waiving, because if this is a hearing.
You didn't waive it. There's nothing to hold.
I have a right to have a probable cause conference.
No.
What?
You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and a reason to believe that you were involved. Do you want to have that hearing so he has to prove his case?
Car crash or personal injury victims. Don't settle for little ball insurance offers if it wasn't your fault and you don't have a lawyer.
Or you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Mitchell has made his arguments today, he ruled on his arguments, and that he preserves his right to...
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that the waiver does not preclude him from arguing jurisdiction at the circuit court level. But likewise, if he holds the preliminary exam today, holds the people to that burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level.
Thank you for the white claw, Andrea.
Court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to...
First notice, what would you like to put me on notice about?
When I served the notice that I requested the criminal bonding information, I requested the bid bond.
Hold on.
I requested the bid bond, the performance bond. I have the affidavit.
There is no bond.
There are bonds. This is
Listen. You can't tell me something and then...
The big bond.
In regards to the bid bond and performance bond and all that stuff, I don't really study that stuff, so I don't think I'm qualified to comment on that. I have heard stories about it, but again, I don't study it, so I don't think I'm qualified to comment on it. You probably need to go and listen to Yusuf. Yusuf will tell you about that. Yusuf L, he'll tell you all about that stuff. He knows more about it than me. So I can't really comment on that, but I can tell you that there's business going on here. And anytime that cases are filed, you have to put up or shut up. You have to put up a security. Generally speaking, you got to put up a security, because if you don't, and you damage somebody, you cause them some sort of injury, like out of pocket cost, because your lawsuit is frivolous. You filed a frivolous lawsuit. You know, you cause them mental anguish. You cause them to lose standing and a good name in the community, shit like that. This is what happens when they file these charges against you. All of that shit happens. And when it happens to you, those are what they call injuries and torts to your person. And somebody has to pay for that. That shit isn't free. Somebody has to pay for that.
Just disagree with me completely. Listen to me, sir. I am not going to let you interrupt me.
Oh, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black rule, okay? That's just the way it works. My courtroom, I get to decide how it's run. There are no bonds required for me to do.
Y'all hear this, man? You can't talk to people like that, man. You don't get to cut me off, you know, and I can't cut you off. You know, we're on equal footing here. Equality under the law is mandatory. We're on equal footing here. You're not sovereign. You're a public servant. You can't do what you want to do, and I can't do what I want to do. But yeah, this is what they do, man. They will do. Everything that this so-called judge is doing, I've seen this, except for you know, cussing at people. I've never heard them say it's a statutory jurisdiction. This is my first time ever hearing say that this is a legislative court and it's a statutory jurisdiction. I've never heard any of them say that. But that's exactly what it is, just to let you know. It looks like a court. It functions like a court, but it's not a court. It's an administrative agency.
What's scheduled today? I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address. Okay, so
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in an affidavit so I can have a?
It's on the record. Order a transcript. I'm not signing anything for you.
Wish you had a professional business address and phone number instead of your home address and personal number? Are you looking to register your business using an address other than your home? Wouldn't it be great if you could read and make...
Sorry about that, y'all.
Okay. Also, I want to also address that. I sent affidavit of fee schedules for violation of my rights.
There are no fee schedules.
Well, I gave you notice, and
great. Then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and you haven't responded to that.
It's so dumb. The last thing was so dumb. The judge just like, I'm never going to respond. He just pauses.
As well as my indemnity bond, which separates me, and I have a private capacity. I am not.
Look, I don't know who this guy is. Y'all gotta, anybody who on this guy, y'all need to stop listening to this guy, man. When it comes to stuff like this, stop listening to this guy. This man is lying to you, man. He's lying to how many subscribers he has? He has 260,000 subscribers. So he has 30,000 more subscribers than the last time when I did a video about him. Why do y'all listen to this guy, man, when it comes to stuff like this? He's lying to you. He is blatantly lying to you. He thinks this shit is funny. This is crazy, man.
The artificial person.
I don't recognize any of
United States citizen. I am actually.
Stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent or you can use or tell me that not just for what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean what? It does. It should mean something.
Please prove it. Please prove it.
Can I do what?
Prove that I am not the artificial person.
I can prove you're Frank Michaud. I can prove.
Okay, so
hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And
you proved it threatening me.
You're threatening me.
But if you're not you, the threat means nothing.
It doesn't mean nothing. But you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus,
Listen, Shaw.
you have.
I've wasted too much time with you. Yes or no?
So-
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. What do you do?
For what?
For contempt of court.
I'm having.
And you can appeal that too. Sentence is 30 days. See you in 30 days.
You just automatically get contempt. See, they will abuse that contempt of court like a motherfucker. They'll abuse the hell out of that. 30 days, just flat. 30 days. Look at all these people. Look at this. Yay, yay, bingo, yay. They're just so happy. These people are stupid, man. I hate to say this about people. Lord, I hate to say it. We just doomed, y'all. We are doomed. Because there are too many. Man, I don't even want to. This shit is depressing. I don't know about for y'all, but this shit is depressing for me to see this shit. Let me go back in and see. Let me see. Anyway, so you're in court for a breach of contract with the legislature, essentially. You could say that. Something like that. I would say that. Got it. Thank you. Let me see. Oh, no problem, Gary. Thank you for the Iowa case law. I added in my paperwork. Its state constitution probably requires that judge to have a surety bond. I'm pretty sure that so-called judge has a bond. I'm gonna say I'm about 99% sure. You know, I could be wrong, but I'm gonna say I'm about 99% sure that he has a bond. He's not gonna tell you that, but the bond is their insurance, y'all. Just like when somebody riding down the street and hits you, or you crashing, y'all crash or something, y'all exchange information or something like that. That's essentially how it works. You file a claim against his bond. If he gets too many claims against his bond, his insurance company is going to drop his ass. That's how it works. They don't understand how much damage is caused by this type of shit, do they? I think they do. I don't think they care. I'm pretty sure that they do, but they just don't care. Look at it. They just so happy.
I object to that.
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely trying.
Take him out of here.
On the color.
I would love it if that appeal went to Judge O'Donnell.
I can give you more than 30 days.
30 days.
I don't think we're going to use it. 30 days. Good to see you, John.
Property-wise, you want to keep your white shirt?
Hey, Ryan, let me know what the next one is.
Is this okay that I think it's your wife?
Yeah.
That's good.
John, ask the wife to come in so he can see his property go to his wife.
Thanks, guys.
It should be the Jackson.
Video. It gets longer than that, but I'm not gonna. There's another video.
Ma'am, would you accept some personal property from your husband, please?
So that's pretty much it for this particular video. But this man here, man, like this guy, he just don't know what the hell he talking about, man. I saw this video. This is my comment right here. I'm convinced this attorney has no clue what he is talking about, or he does, and is misrepresenting. Let me rephrase that. Knowingly and intentionally misrepresenting patently false information to his 260,000 subscribers. This man is one of the two. Because this don't make no sense. Look at this. Just read these comments, y'all. I don't give a shit about your objection. Like, you can't do this, man. It don't work like this. It's not how it works. But this is what you got. This is what you got. They had to do something to this judge about this. I'll be surprised I kind of be surprised if they did, but I don't know, because he was just way out of line. Way out of line. He was patient too, to a certain degree. It's just certain shit that he was saying. You don't get to talk to nobody like that because you a so-called judge. It doesn't work like that. But these people, they think this shit is okay. Man. Anyway, let me go back to the chat. Anyway, I guess let me see. I'm gonna stay on here for about 30 more minutes, y'all. Then I'm gonna get off here. Does anybody have any questions? Any questions? Any cases you want to read? You can send me some information. I'll go over it or something like that. I'm just like, this shit just pitiful, man. It's pitiful, pitiful, man. They just think this is okay. Boy. I'll take some questions, y'all. Or you can send me. I'm gonna send y'all my email. You can send me some documents you want me to look at or go over or something like that. I have a Zoom meeting at 5 o'clock today, so I got to get off here in a little bit and get ready for my Zoom meeting. There's the email address. You can send me something. Let me know when you email it. Let me go and read some more of the comments. I agree. They don't know the facts. They don't know what's going on. They don't even try to know what's going on. They don't care. They just don't care. Like it, man. This shit is depressing, man. For me, it's depressing for me. It just makes me just want to. I hate to even say this, but it just makes me want to give up sometimes. But we can't give up. We just got to keep fighting. Boy, I'm gonna check my email and see if anybody sent me something. I'm checking it right now on my on my phone. Excuse me. Oh boy. It was somebody else. He didn't have any questions though. But anyway, man. All right. I'll come back to the chat. I'm gonna see if I can just find something else that I want to go over, a case or something like that, at least until we go. But that's really what I want to discuss with this dude, Mike. There's some more videos. Let me see. There is. Okay, this is a longer video. Well, it's another video. I think it involves the same guy. I don't know. I'll do another one on this one later. I'm not gonna do all of it today. Let me go to my folder and see what I can find. Store principles, parents' rights, right to travel cases, really good case, lawful vocation. I just got some stuff scattered out all over the place in here. I don't know, y'all. What do y'all want to do, man? I'm gonna go back to the chat. What do y'all want to do? Watch the movie Idiocracy if you haven't seen it. We're heading in that direction. We have a chance to change course, but man, I didn't. When it comes to everybody else, I didn't wash my hands with it, man. I only help people who want to be helped. I'm not finna go out and try to explain to people and protest and let people know what's going on. I ain't doing that shit, man. I'm not doing that. I've washed my hands with that. So if you want to know what's going on, we can do, I'll tell you. But if you ask, I'll tell you. But if not, I'm not going to volunteer any information. I don't have time for that no more. This shit is mentally exhausting. It will stress you the hell out. And I don't have time for that. Anything in particular y'all want to look at, talk about, or go over? Boy. Let me check my email. I'm going to check my email again, see if anybody sent me something. Well, let's see. I'm going to go over Iowa. I'm going to say no, you can't, Levant. Because generally speaking, two courts cannot be exercising jurisdiction over the same case at the same time, except under certain circumstances. So, let me go here. I'm gonna show you it's a principle first. Two courts cannot exercise jurisdiction over the same case simultaneously. I probably spelled it wrong, like I be spelling every damn thing else wrong. All right. Under certain circumstances, they can. So I don't think you can in your particular case. I don't think you can. That's normally something that should be filed in the trial court, if I'm not mistaken. In other words, two courts may not simultaneously exercise jurisdiction over what amounts to the same case. This is Indiana, Ohio. Two courts cannot simultaneously exercise jurisdiction over the same subject matter. The reason for that is because, let's say the lower court issues a judgment in your favor, and the appellate court at the same time or later issues a judgment against you. See what I'm saying? That's just one way to look at it. I'm pretty sure there are numerous other ways to look at it, but that's just one way that I look at it. The rule recognizes that two courts may not simultaneously exercise jurisdiction, blah, 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 over the same case. I think, let's go to Iowa. I want you to see it's in Iowa too. State's brief. Okay. Iowa, 1938, where two actions between the same parties on the same subject and to test the same rights are brought in different courts having concurrent jurisdiction. The court which first acquires jurisdiction, its powers being adequate to the administration of complete justice, retains its jurisdiction and may dispose of the whole controversy, and no court of coordinate power is at liberty to interfere with its action. Does this kind of help you, Levant? Kind of give you some insight on it? This applies pretty much everywhere. It doesn't just apply in Iowa, just to let y'all know. Let's see. What about warrants and contempts? Okay, I'm gonna need you to be more specific when you say what about warrants and contempt, if you don't mind. You should watch Carl Miller Constitution video if you haven't. It's actually on my YouTube channel, Stacy. It's on my YouTube channel. I'm gonna show you where it's at, how to find it. I'm gonna go back to this video later. But my Carl Miller video is on right here. Know Your Constitution is right here. This is Carl Miller. It's on my YouTube channel. That's how you find it. It's like 5 hours long. Let me go back and show you how to find it. So when you go to my YouTube channel, just hit these 2 other links right here, and you'll see it right here. This is how you book me for a consultation, anything like that. You click this link. This is the Carl Miller Know Your Constitution. And this is William Cooper's book, Behold the Pale Horse. It's an audio book. Right here. Okay. In some cases, a superior court judge can consolidate what's before them with a related case in inferior court. I'm a little confused as to what you're talking about, SG. Otherwise, one has to finish before the other starts. That's kind of true. They do like the courts, like once you appeal a case or whatever, they do retain jurisdiction to dismiss the case for lack of jurisdiction. Even if it's appealed, if I'm not mistaken. So the demurrer would need to be filed in the Court of Appeals. If it's for like a fundamental due process error or something like that, you could probably do it. Yeah. But if not, then no, because you need that it's an argument that you would have had to raise in the trial court. Generally speaking, any argument that you're raising for the first time on appeal, they're going to deem that it's waived. They're going to say you waived it unless it's something challenging due process or subject matter jurisdiction, something like that, which is also a due process violation. No arrest without probable cause supported by a warrant. Therefore, contempt is unconstitutional. Well, it depends. It depends on what type of contempt you're talking about. Well, no, it doesn't, because they can like how they did this guy in this video. They don't have carte blanche to just hold you in contempt for whatever they deem you to be in contempt of. It doesn't work like that. No, it doesn't work like that. Doesn't work like that. Okay, I got a doc. Let me see. Are you okay with me, Levant, reading this document? Like downloading it and showing it on the computer? Are you okay with that? Because there's going to be a lot of other people see it. That's 21 pages. Brief of appealee. State of Iowa. If you're okay with it, let me know and I'll pull it up and we can go over it. You can just, give me your questions that you have about it, and I'll do my best to answer it. If once the appellate court, generally speaking, this is most of the times, all right, not all the time, but most of the times, when an appeal has been perfected, in other words, when you have perfected the appeal, you paid the filing fee or you filed a motion to, waive the fee so you can, pay it. I mean, it's waive the fee so you can proceed with your appeal. You filed your notice of appeal, stuff like that. Once that has been taken effect, anything that you want, almost anything that you need, that you try to file in the trial court, you're going to need to file a motion for leave of court in the appellate court, to see if they'll allow you to file something in the trial court, if that makes sense. Constitutional rights have to be waived knowingly and willfully. Well, yeah, but I think you're confusing waived with expressed, because I don't think they have to be expressly, or I don't think all of them have to be expressly waived. They should be, in my opinion. I think they should be, because they're not allowed to implicitly say that you knowingly, intelligently, and voluntarily waived your right to counsel from a silent record, meaning there's no evidence on the record suggesting that you waived it. So they're going to presume that you waived it. They're not allowed to do that. $21 pages. When did they turn this brief in? This was, what's the date? November 14th. This was 3 days ago. Okay. Yeah, Levant, are you okay with me pulling this document up and showing it and reading it to you? I'm not sure if you can hear me. Okay, thanks. It was raised at sentencing, and the so-called judge agreed with me, but proceeded. Oh, okay. So if it's that subject matter jurisdiction argument, you can raise that for the first time on appeal. If it's that subject matter jurisdiction argument that you were talking about, you can raise that for the first time on appeal. Let me show you what I'm talking about. Well, I'm gonna wait to see if that's what you're talking about first. I'm gonna wait and see if that's the case you're talking about, and then I'm gonna go and pull it up. Because subject matter jurisdiction is a due process issue. They can't ignore the fact that they don't have jurisdiction. It doesn't work like that. They don't have discretion to ignore the fact that they don't have jurisdiction. That's an abuse of discretion. Well, I take that back. That's not even abuse of discretion because they don't even have discretion to do that. I'm gonna pull up his document, then I get back to you. I'm gonna come back to the chat. That's right. Anytime. Anytime. So let's go to Google, Gmail, states brief. All right. Any questions that you have about this document? I'll try to answer it to the best of my abilities because I'm not too familiar with Iowa so-called law, but I'll try to answer it to the best of my abilities. They're arguing that the state offered sufficient evidence to convict the defendant of second-degree theft and 50 timber buyer violations. Let's go back here. Okay, I appreciate it. It says the dealing with waivers of constitutional rights. Okay, appreciate that. Subloc heard you on the call yesterday with the gems. What's good? What's good, Rando? Appreciate it, man. Yeah, man. I just be trying to teach people. I'm okay. Okay. All right. So what type of questions that you have about this brief, Levant? And I'll check it out for you. Also, let me see. I'm okay. Lies. I'm gonna need you to be more specific than lies. Also, while I'm live anyway, of course y'all know my lives are free, but if y'all want to send me something to my Cash App, I'm gonna go ahead and put my Cash App down here. I don't care what you're seeing, 50 cents, $1, $2, $3, I don't care what it is. This is completely voluntary. You do not have to do this. I'm not gonna be mad at you if you don't do it. But it's just if you want to send me something. Appreciate it. Let's see. They can't ignore You're in an administrative agency. They can't ignore it. I'm just going to tell you that now. Also, I think I answered this question on this one. But you can go and read these cases. Let me see. I'll post one of these cases in the chat for you regarding two courts exercising the same jurisdiction over the same case or whatever. You can just go and read it for yourself. I'm gonna post this in the chat for you right there. The old cases are the really good cases, y'all. The hell is that? All right. It's probably typing his questions. I have to see I have to know what your questions are. But let me go and I'm gonna do like I'm gonna just read over the document and I'll come back to the chat and see what your questions are. Where's the damn? Where is it? Right here. Okay. This case can be decided based on existing legal principles. So transfer to the Court of Appeals is appropriate. Nature of the case: a jury convicted the defendant, Jason Levine Ferguson, of second-degree theft and 50 timber bar violations. He appeals his conviction. Statement of the facts. All right. This is the state's brief. All right. So I'm gonna tell you right now, because this is the state's brief. I'm going to, and I could be wrong, okay, but I'm going to automatically assume that they are misrepresenting facts in this brief. I'm just going to automatically assume that because this is the state. And that's what they do because I've had it done to me before. All right. So I'm going to automatically assume that even though I could be wrong. This is 21 pages. Let me see. A deer hunter called authorities when he noticed someone cutting trees. Blah, blah, blah. The defendant admitted that he had gotten a lot of trees from the area this year, though not like semi-loads. Let me see. He claimed that he had been cutting in the area since the winter of 2019 to rebuild his house for firewood. None of the body camera video exhibits have document numbers associated with them. While grinning, the defendant said that he was not logging cause. It sounds like something illegal. I was cleaning it up, helping the habitat. He took the officers to a huge bur oak stump that he cut and said it took a month to remove the tree. He showed one officer the accuser's website that he used. I'm pretty sure, let me see. Let me go back to the chat. No rights in legislative tribunals, only 14th Amendment privileges. Okay. I was just mainly wondering how the state can say the state proved something without actually proving it. I mean, they gonna do that, but you just got to go back and you got to disprove it. You got to rebut the presumption. I mean, you got to dispute their argument. But if the subject matter jurisdiction, you can raise that argument anytime. You can raise it on appeal for the first time. You can raise if it's a due process issue or like a fundamental due process issue, you can raise it for the first time on appeal. I was just mainly wondering how the state can say that the state proved something without actually proving it. Let's see what the elements are. Let me see if I can see what the elements are. I'm going to see if they're going to do it in here. The state offers sufficient evidence. Preservation of error. The defendant preserved error by proceeding to trial. Standard of review. This court reviews the sufficiency of the evidence for correction of errors at law. It considers all evidence and views it in light most favorable to the verdict, including legitimate inferences and presumptions that may fairly and reasonably be deduced from the record evidence. merits. To convict the defendant of theft, the state had to prove on or about the first day of April, blah, 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 through the 24th of October 22nd, the defendant took possession of control of trees from Stubbard Wildlife Management Area. The defendant did so with the intent to deprive, blah, 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 of their property. So that is the property at the time of the taking belonged to NHF and or the state of Iowa. Okay, so looks like two elements. Maybe it looks like 2 to 3 elements. To prove the 50 timber bar violations, the state had to prove on or about the first day of blah, 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 the defendant did cut or caused to be cut down or appropriated timber, to wit, one species of tree from the Stubbard Wildlife Management Area without purchasing it. Defendant knew he had no legal right to do so, and the property at the time of taking belonged to blah, blah, blah. The state also had to prove that the defendant did not make a reasonable mistake of fact about who owned the land where the trees he cut, where he cut the trees, something like that. The defendant argues that there was insufficient evidence to find him guilty of all counts. He asserts that the state failed to prove, 1, the state or NHF owned the 50 trees that the defendant was convicted of cutting. He cut them, B, he cut them between April 1st, 2021 and October 24th, 2022. C, the defendant is who cut, appropriated, or took control of the trees. Or D, he did not mistakenly believe he had permission to cut the trees. None of the defendant's claims prevail. The state takes them in turn. The state offered sufficient evidence that the defendant cut down 50 trees owned by the Natural Heritage Foundation or state of Iowa. And go back to the chat and see what's going on. That's not Article 1. Yeah. Let me see. How about this? Administrative can be used for executive purposes. Administrative has the appearance of legislative, but is used for judicial and executive purposes. They're really not used. They don't have legislative authority or judicial authority. They call it quasi. But they just treat it. What they really have is plenary power. That's really what it is, because you're in a territory. You're in a territory, and not only that, it's an administrative agency. All of this stuff makes so much sense to me. It makes perfect sense to me. Administrative hearings are conducted by the individual department like DOT, yep. Unemployment, welfare, yep. Those aren't in a courthouse and are administrative, not legislative. Yeah, that's right. That's right. The reason for that is they're following statutory procedures. So if those proceedings are administrative, then you can reasonably conclude when the so-called judge starts following statutory procedures and starts enforcing statutes that she or he is also acting in an administrative capacity. Because that's what's going on. That's what they're doing. Hold on, what was that? Quasi-judicial. Yeah, court-like. Kind of sort of like a court, but it's not really a court. Yeah, I like that. Let me show you this BS that they like to play. Man, these folks be playing games, man. Let's see. Quasi-judicial means court-like. This always make me laugh every time I read it. Quasi-judicial means court-like. Some common usages of the term quasi-judicial in a legal sense include: quasi-judicial refers to a proceeding conducted by an administrative or executive official or organization that is similar to a court proceeding. A hearing conducted by a human rights commission. A court may review a decision arising from a quasi-judicial proceeding. Quasi-judicial can also refer to a judicial act performed by an official who is either not a judge or not acting in their capacity as a judge. That's what they're doing. Almost. Yeah, almost. Kind of, sort of, maybe. You know, almost there. Just... I like almost better, though. That shit funny. Oh, boy. Make them look like they're judicial. Yeah. Yeah. That's a good one, too. I think almost is funnier, though. Because they make their own internal regulations. Yes, they do. And those regulations, although they are not laws, they do have the force and effect of law. They're a species of it. All over their members, their corporators, their executive officers. The same thing with statutes. It's the same damn thing. You enforce your law, your rules in your house, how you run your house, over everybody who comes into your house. Even though that's not the law, in the sense that it applies to everybody who is outside of your house. To everybody who is inside your house, that is the damn law. And if they don't like it, they can leave. That's the law. So departments are quasi-legislative and their administrative hearings are quasi-judicial. That would be correct. That would be correct. This is why a city is an administrative agency. A town is an administrative agency. A county is an administrative agency. The municipal judge represents the so-called judicial branch. The city council represents the so-called legislator. And the mayor represents the so-called executive. It's a miniature state. You're in a territory. It's a state within a state. That's what it is, a state within a state. Thanks for the donations, y'all, by the way. I don't know if you want me to say your name. Well, I don't think anybody here knows you. Nick, thank you for the donations. I really appreciate it. But they are still bound by statute and constitutions. I agree with that. I agree with that as well. It's a big mess, and that's the big problem. Okay, so let me just get back to this a little bit. The NHF bought the study area on July 24th, 2020. It transferred that property to the state of Iowa on August 2021. Thus, for the state to prove that NHF or state of Iowa owned the 50 trees cut by the defendant, the state had to prove he cut them after blah, blah, blah. The state did so. Ross Baxter negotiated that stuttered purchases for NHF. He testified that he walked to the stuttered property in October 2020, but saw no evidence of prior logging and did not see any evidence of trees being removed from the property. From that testimony, the jury could find that the defendant had not cut any trees on the stubborn before October 2020, which was after NHF bought the property. From there, the jury could find that he cut all 50 trees when either the NHF or the state of Iowa owned the property, because those were the only owners after 2020, October 2020. The state also proved that the defendant cut all 50 trees from the studded area. An expert found 55 tree stumps, all cut on the stubborn area. Those 55 stumps include the 50 trees the defendant was convicted of cutting, so the state proved all 50 trees, producing the 51 convictions were cut on stuttered area. The state sufficiently proved when the defendant cut the 50 trees. Well, they didn't prove jurisdiction. If I'm not mistaken, you challenge the jurisdiction. Let me see. The date is not an element of theft or timber buyer violation. So the state only had to prove he committed each offense when doing so was a crime and within the limitations period. The state did so. What this is, he's being, whoever this is, they're being prosecuted by they were prosecuted by an administrative agency. That's what they were doing. An administrative agency prosecuted him. You crazy if you think you're gonna get a fair hearing in that motherfucker. You're not finna get that. Like, no, you just not finna get that. It's not gonna happen. Actually, underground regulations are not allowed. If you look up underground regulations, I would appreciate it. Let me see what you mean by underground regulations. See, I didn't know that. Let me see. What is the meaning of an underground regulation? The term underground regulation is applied to any law or bill that is under process. What they mean by that? This term is generally used to describe any law or bill for which the government is making provisions. Therefore, the period in which the concerned authorities examine or review of the bill is known as the period. Well, this kind of up here says something a little different. Administrative Procedure Act. This is. Let me see. I'm not sure. Is there a specific so-called state for underground regulation? The definition for underground regulation that you want me to look up? How did they prove it? If they did, they should be able to show the proof. Yeah, they're supposed to be able to show the proof. Let me go back. I'm gonna come back to this. What is this? Auditron. I'm gonna come back to this, and I'll get back to you in a little bit. Thank y'all for the donations. I really appreciate it. Let's see. Let me go back down a little bit. Iowa law requires the state to prove that a crime occurred within the limitations period, not the specific date it occurred. As the Iowa Supreme Court has put it, a defendant is not immune to conviction for thefts committed in 1982 simply because the trial information charged him with committing theft on or about January 1983. That rule applies even when the instructions list a date that the criminal act occurred on or about, as they did here. Neither theft nor timber buyer violations require proving a specific date. Thus, the state did not have to prove the date. Okay, we'll get to the elements of the offense. Well, first you need to get to jurisdiction. That's the first thing. Instead, the state had to prove the defendant committed the theft on January 25th, 2020, and the 50 timber violations after July 1st, 2020. The general 3-year statute of limitations for felonies and serious misdemeanors applies to all 51 violations. Iowa Code, there he is, notice of code. Anyway, territory. Because the state filed its trial information on January 25th, 2023, the limitations appeared to extend it to January 25th, 2020. Normally, the state would have been able to convict the defendant for criminal acts it proved that he committed after blah, 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 but the defendant correctly observes that date, July 1st, 2020. The timber buyer provision did not apply to him. That required the state to prove the timber violation occurred after, okay? stating that the federal and state ex post facto clauses forbid the application of a new punitive measure to conduct already committed. Come on now. The state offered sufficient evidence that the defendant committed both second-degree theft and all 50. Okay, where's the evidence? Okay. As explained in the preceding subsection, the state proved that the defendant cut down every tree after October 2020 because cutting, it doesn't matter if he cut down these trees or not. What matters is if this definition applies to him. If the definition for timber buyer does not apply to him, then you didn't convict shit. If I'm not mistaken, the definition has to apply to him. They can't enforce ordinances and statutes beyond the scope in which the legislature intended them, or in other words, authorized them to enforce it. It doesn't work like that. You violate due process when you do that, and they exceed their authority when they do that. They call it ultra vires or something like that. Are you going to regulations or illegal? Let me see. Each state has to be promulgated through the secretary. I'm sorry, each statute has to be promulgated through the Secretary of State. Okay, so if it's general, then it applies everywhere. Okay, are you going to regulations or illegal? No, I was let me see, right, and the judge denied the jury instruction of the definition of timber buyer. Well, he violated due process. He can't, to be honest with you, he don't have discretion to do that. I don't think he has discretion to do that. He violated due process. Yeah, that's a violation of due process. You can't just presume that an element to a crime exists. It doesn't work like that. You violate due process when you do that. And that's essentially what he did. They're gonna presume that you're a timber buyer. It's just like with that ebook, the child support ebook, when they just presume that you're an absent parent without ever having you an evidentiary hearing on whether if you're an absent parent or not. That's what they're doing, because in order for them to get you with child support and all that stuff, you have to be an absent parent. That's an element that they need to prove. So in your case, they have to prove that element, timber buyer. They have to prove that you all qualify for this legislative definition of timber buyer within the meaning of this statute or this ordinance or this regulation. And if you don't, then this shit doesn't lawfully apply to you. These folks get on my damn nerves, man. These folks get on my damn nerves, man. You're welcome. You're welcome, man. Yeah, I'm gonna take me a little break because I have a Zoom meeting at 5 o'clock that I gotta prepare for. So I'm gonna get off here. I'll take like a few more questions before I go. I'll get off in like 5 minutes. So if you got any more questions, go ahead. What was it? He wanted me to look up underground regulations. Let me see. Underground regulations. Illegal. Look up a legal definition. An underground regulation. I'm not sure if this is what you're talking about. So if this is it, let me know. Excuse me. An underground regulation is a rule that a state agency issues, uses, or enforces without following the Administrative Procedure Act. Well, shit, I don't think they can do that, then. I could be wrong, but I mean, I don't think they can do that. Not no administrative agency. Because, I mean, it allows them to violate the Administrative Procedure Act. I don't think they can do that. A rule that a state agency, okay, yeah. Example, guidelines, bulletins, manuals, instructions, orders, standards of general application, or other rules. What happens if an agency engages in underground rulemaking? The action is invalid and the agency must complete the formal rulemaking process to follow that prior guide. So this seems to be some sort of procedural so-called law that dictates how administrative agencies manufacture or come up with their own internal rules or regulations or something like that. That's what it seems like. I could be wrong, but that's kind of what it sounds like to me. I appreciate that, Levant. I really do, man. I appreciate it. I have a technical question about the Sixth Amendment, which the Supreme Court ruled is protected as a privilege under the Fourth Amendment. Jurisdictions are listed under Article 3 and Section 2. Okay, we can talk about that when we get your session in. We'll do that. Got here late. Next video. Good show. Is Trump good for the country? I don't really too much participate, in politics. I think, generally speaking, I think all of them are just full of BS. But in this particular election, despite their past as individuals, as what they did in their private life, and as businessmen, businesswomen, their careers and stuff like that. I think Trump was the better candidate. I think he was, even though I didn't vote for him. I didn't even vote, to be honest with you. I don't vote. I think they just all full of BS. It technically doesn't limit courts to the 4 jurisdiction we usually hear about. Can we take a look at that and go over the Dred Scott case sometime? Ooh, that Dred Scott case is long. I try to, man. That case that long. More specifically, is there a case law that those jurisdictions have to apply to Article 1 courts? Probably, I would say yeah. And the reason I say that is because it's a territory, and since it's a territory, we both know that there's case law that establishes that they have plenary power, generally speaking, within these territories. So what they're doing is they'll create a common law act, and they'll invest a so-called one of their administrative agencies with original jurisdiction to adjudicate the case. That's what they do. Or they'll create an equity act or something like that. What I mean by common law acts and equity acts is they'll create acts and the remedies within these acts that you can seek, like a common law remedy or equity remedy, something like that. What they do is in the territories is they mimic the common law jurisdiction. They mimic the equity jurisdiction. They mimic the admiralty jurisdiction and the maritime jurisdiction. They copy it and they modify it a little bit to fit how they want it to be. That's what they do. You're in a territory. A lot of people, I didn't, to be honest with y'all, I did not even know this. I thought the territory was only in the District of Columbia. I did not know that all these incorporated towns, counties, and cities were territories. Until I started reading cases about municipal corporations. And when I started reading the cases, they always referred to it over the territory, the municipal corporation, exercising territorial corporate jurisdiction or territorial jurisdiction or corporate jurisdiction. That's what they all said. And when I read those cases, that's how I came to the conclusion that this is a fucking territory. It's a territory. And that's exactly what it is. It's a damn territory. It's exactly what it is. So the Judiciary Act would be the controlling power for the nature of their causes of actions. I would say so, yes. Yes, I would say so, because remember, These are territorial so-called courts. These are courts of extremely limited jurisdiction. So I would say so, yes. The Judiciary Act, I remember when I was talking to Yusuf yesterday, the Judiciary Act created another Supreme Court. That's what it did. That's exactly what it did. It created a Supreme Court for their territories. That's exactly what it did. When you file a complaint in a U.S. District Court, there's a 99% chance that somebody's going to do it under a statutory jurisdiction. When you file an appeal to a U.S. Court of Appeals, a federal U.S. Court of Appeals, there's a 99% chance that somebody is doing it under a statute. When you file an appeal to the U.S. Supreme Court, there's a 99% chance that somebody is doing it under a statute. All of these statutes were created by Congress. It's a fucking territory. It's an administrative so-called court. That's what it is. I've seen this shit. This makes so much sense to me now. Well, no, I wouldn't say that because I mean they still have to follow the Constitution. You know, they don't have any discretion to ignore their duties. When you demand to know the nature of the action, they have to tell you. They're not going to tell you, but they have to tell you. And if they don't tell you, they violate due process. I mean, that's how it works. He says it's not admiralty. I don't think you're in a damn, it's like you're in a damn star chamber or the damn outer limits. I don't know what it is. All right. I don't know what it is. It's not really admiralty. It's like a colorable admiralty jurisdiction. Everything they do over there in the territories is colorable. They have colorable laws. Statutes are not laws. They have colorable courts. Administrative courts are not courts. And they have colorable money. Federal Reserve notes are not money. Everything over that bitch is a fiction. Everything. Legal persons. That's a fiction. The court is a fiction. You know, all the businesses over there are fictions. The banks over there are fiction. They're legal persons. The public servants over there, they're all fictions. They're all fictions. Territory is not necessarily admiralty. I agree with that. I agree with that. I don't think it's authentic admiralty. I think it's colorable. They're mimicking it. They're copying it. That's what they're doing. Admiralty and commercial courts have always existed in American history. I don't see how they're different. I mean, they seem like they're the same damn thing to me. I could be wrong though. I'm not a guru. I could be wrong, but they seem like they're the same thing to me. Unless one was specifically governing commerce over the sea, you know, over the actual water or whatever, and one was actually doing adjudicating cases of commerce on the land, you know. But I mean, it would kind of be the same thing, you know, something like that. Like, I don't know. I'm not a guru, y'all, so don't hold me to this, y'all. I make mistakes. Is that the people are separate from the government and all the regulate. Y'all want to know what's so funny? Everybody who is not, if you are not a member of the territory, you are a foreigner. And I'm not talking about like foreign to this country. I'm talking about foreign to their government, foreign to their territory, foreign to their corporate territorial bylaws. You're a foreigner. But anyway, look, I gotta go, man. I've been on here a little longer than 5 minutes. I'm gonna go ahead and get on up out of here and prepare for my thing I gotta do. And that'll be it. hopefully, I helped, as many people as I could. Thank y'all again for the donations. I really appreciate it. The Supreme Litigant is out. Peace, y'all.